For almost 60 years, the federal government has collected workforce demographic data from large employers. The information helps the Equal Employment Opportunity Commission identify patterns that might suggest discrimination in hiring, promotions, pay, or termination. Now, the Trump administration is moving to end that reporting requirement. On paper, discrimination remains illegal. The Civil Rights Act hasn't changed. But here's the practical problem. Civil rights laws are only as effective as the government's ability to enforce them. Imagine a company with thousands of employees. If women are consistently passed over for promotion or if minority applicants are rarely hired, those patterns may not be obvious from any single complaint. The EEOC has historically used workforce data to identify trends and investigate potential violations. Without that data, enforcement becomes much more reactive. Instead of spotting systemic problems, regulators may have to wait for individual workers to come forward, file complaints, and prove their cases one at a time. A good example is the EEOC's case against Bass Pro Shops. Investigators noticed that stores across the country were hiring remarkably few Black and Hispanic employees compared to the surrounding communities, which prompted a deeper investigation that eventually led to a $10.5 million settlement, although the company denied wrongdoing. The key point is that investors only spotted the pattern because they have access to workforce demographic data. And under the current administration's plan, that data will no longer be readily available. This is why the move to end reporting requirements has been met with some resistance, and critics say that it's going to make enforcement of discrimination claims harder in the future.